And then it's going to turn. Okay, that's good. How's this sound?
like any other person. She is young. I think she's 2 years younger. But looks like they're sleeves. Yeah, you may be laughing so hard during arguments.
I'm going to love it. So after Dory.
So how many people on the Supreme Court do you think have ever baked a cake?
Have ever been?
Baked a cake.
I'm trying to remember. Marty used to say that
Ruth does not cook.
That there were these great cooks on the court. That the Congress husband.
Right, and Scalia was a great cook. But Thomas, no. Alito, no. Kennedy, no. Roberts, no. Breyer, certainly. The women on the court are here because they're the cooks. My sister plays poker occasionally in Southern, and she is a fierce poker player. But not apparently a domestic guy.
We have to be undignified and drink out of it.
Pardon?
We have to be undignified and drink right out of it.
Yeah, no silver chalice for that.
So they got to us about 1:30.
Yeah, for me, the only difficulty is staying up this day. I'm not a night owl. Yeah. There's nothing in here about the case.
Spelled our names right.
Yeah, well, that's what
teaching 245 is absolutely.
7 of our faculty will present a moot court, or in non-legalese, a mock argument. The case at issue is Masterpiece Cake Shop versus Colorado Human Rights Commission, which you'll hear about in just a few minutes. As you know, later this year, the case will be argued just up the street in front of a panel of judges almost as robust as this one. Before we begin the argument, I will very briefly introduce the faculty advocates and justices. First, our advocates. Professor David Vladeck will represent the petitioner, Masterpiece Cake Shop. Professor Vladeck is one of the nation's leading experts in complex litigation. Before becoming a full-time academic, he spent over 25 years with Ralph Nader's Public Citizen Litigation Group, a national public interest law firm where he was the director of litigation. Having served as an adjunct and visiting faculty member at Georgetown since 1984, Professor Vladeck joined our faculty full-time in 2002, running a division of our Institute for Public Representation Clinic. In 2010, he took a leave from our faculty to join the federal government, where he served as director of the Bureau of Consumer Protection of the Federal Trade Commission. Rejoining us, he teaches civil procedure now and a range of litigation and consumer protection courses. Professor Vladeck has argued 4 cases before the United States Supreme Court. He's briefed and supervised many others and argued more than 60 appeals in appellate courts. Section 7, you will be studying with Professor Vladeck this fall in civil procedure. Professor Vladeck has a worthy adversary this evening. He is Professor Michael Gottesman, who will represent the respondent. Professor Gottesman joined our full-time faculty 29 years ago. Prior to that, he practiced with the Washington, D.C. firm of Bredhoff and Kaiser for 27 years, specializing in the fields of labor law, constitutional law, and civil rights. He has argued 21 cases in the United States Supreme Court, and he has briefed dozens of others. Professor Gottesman is a Renaissance man in the classroom at the Law Center, regularly teaching courses on everything from torts to constitutional law, property, criminal justice, intellectual property, sports law, and I could go on. Many of you will get to know him this year as he will be teaching Con Law 1 in Section 1 in the fall, and then Property in Section 2 and Criminal Justice in Section 4 in the spring. Next, our justices sitting at the bench. I'll introduce them starting from your left. Our first Associate Justice is Professor Nan Hunter. Professor Hunter joined the Georgetown Law faculty 9 years ago, and from 2013 to 16 served as our Associate Dean for graduate programs. She's one of the nation's leading scholars and teachers on both sexuality in the law and health law and policy, and she is the co-author of the leading casebook, Sexuality, Gender, and the Law. From 1993 to 96, she served as Deputy General Counsel at the Department of Health and Human Services in the Clinton administration. A graduate of Georgetown Law in her early legal practice, Professor Hunter specialized in constitutional and civil rights law as a litigator at the ACLU. Professor Hunter will be teaching a small group of you in Section 3 in the Legal Justice Seminar this fall. Our next Associate Justice is Adjunct Professor Dori Bernstein. Professor Bernstein is the director of Georgetown's Supreme Court Institute, and she'll tell you more about that in just a minute. She also teaches an upper-class practicum course that prepares students to serve as appellate law clerks. Before joining the SCI, she served for nearly 18 years as an appellate litigator in the Office of General Counsel at the U.S. Equal Employment Opportunity Commission, where she briefed and argued cases in the federal circuits, and she worked with the Office of the Solicitor General in numerous cases representing the interests of the United States at the U.S. Supreme Court. After law school, she clerked for then-Judge Ruth Bader Ginsburg on the U.S. Court of Appeals for the D.C. Circuit and was a trial attorney in the Civil Rights Division of the U.S. Department of Justice. Next on the bench, in the center of the bench, is our Chief Justice tonight, Professor Martin Lederman. Professor Lederman joined the Georgetown Law faculty 10 years ago, and after law school, he clerked for federal judges in both the Eastern District of New York and the U.S. Court of Appeals for the First Circuit. He's done several stints in private practice, including at Bredhoff and Kaiser, and he also spent nearly a decade as attorney advisor in the Department of Justice's Office of Legal Counsel. More recently, he served for 2 years in the Obama administration as Deputy Assistant Attorney General. He's one of the nation's leading writers and commentators on the jurisprudence of the Supreme Court. A small group of Section 4 students will get to know him in Con Law in the spring. Sitting next to Professor Lederman is our third Associate Justice, Professor Paul Smith. Professor Smith joined the Georgetown faculty this past year as a distinguished visitor from practice. He's currently the Vice President for Litigation and Strategy at the Campaign Legal Center, a nonpartisan organization that advocates for the right to participate in the political process. He previously chaired the Supreme Court Practice Group and the Election Law Practice Group at the national law firm Jenner & Block. Professor Smith is one of the nation's leading Supreme Court advocates. He's argued before the court 19 times. One of his most significant victories was Lawrence versus Texas, the landmark case addressing the constitutionality of a state law criminalizing consensual sodomy. Professor Smith is former chair of both the American Constitution Society and Lambda Legal, and he will be teaching Con Law 1 to Section 5 students this fall. And last, not least, our fourth Associate Justice is Professor Irving Gornstein. Professor Gornstein is Executive Director of our Supreme Court Institute. Prior to coming to the Law Center, Professor Gornstein was a litigator in the appellate practice at the law firm O'Melveny and Myers, and he served stints in the U.S. Department of Justice, first in the appellate section of the Civil Rights Division, and later in the Solicitor General's office. Alongside Professors Gottesman and Smith, Professor Gornstein holds a prominent place in the cohort of leading Supreme Court advocates, having argued 36 cases before the United States.
Oops, I'm up to 38 now.
Oh my goodness. Wow, you've been busy. Professor Gornstein will teach criminal justice in Section 5 when he's not arguing before the Supreme Court. Before we begin the argument, I'm delighted to welcome to the podium Professor Bernstein to say a few words about one of the true gems at Georgetown Law, the Supreme Court Institute. Professor Bernstein.
Welcome to Georgetown. We're really happy you're all here. I'm director of the Supreme Court Institute, where we hold moot courts to prepare advocates who have cases to argue in the U.S. Supreme Court. A moot court is an argument practice session. We recruit a panel of 5 lawyers who read the briefs and act as justices. So the lawyer argues the case as if they're in court, and the justices pepper them with questions. After the Q&A, we give the counsel our best advice about how to answer the questions most persuasively and how best to argue his case. You're about to see a simulated argument in Masterpiece Cake Shop versus Colorado Civil Rights Commission, a case the Supreme Court will hear later this term. If you like this sort of thing, and especially if you might like to be a courtroom lawyer someday, you've come to the right place, because this is the only law school in the country where students actually get to watch lawyers in virtually every case the court hears each term prepare for their oral arguments. Georgetown is also the only law school in the country that's a 20-minute walk away from the U.S. Supreme Court. So it's easy to head over there to observe an argument. It's the best show in town, and it's free. But you do have to get up really early to nab a seat. So if you're not a morning person, you can just come and watch the moot here, and then after the oral argument, you can read the transcript or listen to the audio and find out how we did channeling the justices. So we'll start mooting cases in the last week of September, the week before the court's first arguments of the term. We'll be mooting Masterpiece Cake Shop later in the fall, as well as nearly every other case the court will hear. Each of you will see one of these moots as part of your legal practice class, but you're welcome to attend as many as you like. As moots are scheduled, we'll send you an email. Just follow the directions. You'll get to our website. It'll have the list of all the cases we'll be mooting, the schedule of the moots, and you just have to write to us to request an invitation to get cleared, go through conflict clearance, and then you can attend the moot court. And if you want to come hear about some of the other headliners this term, you should plan to attend our annual term preview panel and, very important, pizza lunch on Thursday, September 14th from 11:30 to 1 on the 12th floor of Gewertz. We'll send out an event announcement by mail next week, so keep an eye out for it. And finally, you can always pay me a visit in 463 McDonough, that's this building, to learn a bit more about upcoming moots. And as added incentive, I keep a very large jar of chocolates on my desk at all times.
Professor Bernstein, thanks so much. Before we begin the moot, I am delighted that Dean Traynor will share some observations with you about Georgetown's unique excellence in the practice and instruction of appellate advocacy. Dean Traynor.
Well, I have to say, you've got a fabulous introduction. This is really one of the gems. And, no school can offer anything like this. The idea that when you take first-year legal writing, as you heard from Professor Bernstein, you get to sit in on a Supreme Court moot, listen to the advocate, try out their arguments before a panel like this, talk to the advocate afterwards. It's an amazing introduction to appellate advocacy at its highest level that you can't get anywhere else. And we have a faculty that has a depth in appellate advocacy that is unmatched in the history of the United States. So, this panel here, I was going to say 81 Supreme Court arguments between our bench and our advocates. I now realize it's 83. And, you know, we could do this again and again and again. We have, you know, between our adjunct and our full-time faculty, so many of the leading appellate advocates in this country teach at Georgetown. It's phenomenal. So you'll get a sense of that tonight, but it's an extraordinary privilege for us to have attorneys, faculty of this level of excellence, and nobody else is getting the introduction to appellate advocacy that you can get at Georgetown Law. So let me turn matters over to Dean Balin.
Thank you, Dean Traynor. All right. Professor Lederman, still as Professor Lederman, is going to give you a very brief introduction to the case. I know you've read his terrific introduction that we sent around. He's going to explain the format for the argument that we're using here tonight, and then he's going to assume his role as Chief Justice. I'm turning it over to Professor Lederman, and I am becoming the timekeeper.
Thank you, Mitch, and welcome to Georgetown. It's a privilege and a pleasure to serve in this august capacity here. The First Amendment is 226 years old this year. You'd think by now we would have figured out whether cake is protected speech. But in fact, that's still an open question, and so therefore here we are before the U.S. Supreme Court. And many of you might be thinking, well, that seems a little bit absurd, but cake can be expressive in various ways. Think of Alice in Wonderland. Seeing the cake that says, "Eat me," that's probably what most of you see when you see cake. That's the message that it sends, and she has to eat the cake to get out into the beautiful garden in Wonderland to reach the key. Some of you may have seen Tina Fey last week on Saturday Night Live, arguing that the most robust and effective form of political resistance is to eat sheet cake, and she demonstrated as such. So here, of course, as our summary suggested to you, the process of making and serving the cake might have at least two different expressive functions, and that might be one of the topics that we get to explore today. One might be that the cake itself might be expressive. It might express something about the couple who is serving the cake at their celebration. And the making of the cake might be expressive activity as well. And so one question is the First Amendment to the U.S. Constitution implicated at all here? Is this expressive activity? And we probably will get into that a bit, but I just want to clarify for you that that's hardly the be-all and end-all of the case. That deciding that particular activity or is expression that might be protected by the First Amendment doesn't mean that a state can't do anything to regulate it. Although the words of the First Amendment seem pretty absolute, Congress shall make no law abridging the freedom of speech. In fact, legislatures make laws that restrict speech all the time. Bribery prohibitions, perjury prohibitions. The law of contract that you'll be learning this year is all about legal regulation of a form of speech, entering into contracts. And so whether it's speech is only the beginning of what we will be discussing here tonight. I'm not going to go over the facts of the case in detail because I'm going to assume that you've all read the summary, and if you haven't, you'll get a sense of it during the argument. But I just wanted to give you a couple of points of perspective that you might have been wondering about. And the first is the relationship between this case and the recent decision of the Supreme Court 2 years ago to recognize that the 14th Amendment of the U.S. Constitution ensures that same-sex couples are entitled to marry and that a state cannot deny the privilege of state-sanctioned marriage to same-sex couples. Now, part of what you might hear tonight, and certainly what you'll hear if you go to the moot court in this case or go to the argument or listen to it in this case, is the question about the analogy between this and if the baker was resisting or was discriminating on the basis of race. Why should this be any different? And many of you probably know that in 1967, the Supreme Court decided that states could not prohibit the marriage of interracial couples. And it took another almost 5 decades, almost a half century for the court to hold that same logic applied to same-sex couples. But there is a difference in the way the court approached the two cases, even 50 years apart. In 1967, in the famous Loving versus Virginia case, none of the justices would have even thought to suggest that those who were opposed to interracial marriage had any legitimate moral ground for such opposition. Once the court decided that was constitutionally protected, it was in part because it was something that there was a moral consensus about. Not so true about gay marriage, okay, or about same-sex marriage. So in a case just before the Obergefell case in 2015, Justice Alito warned that if the court were to recognize same-sex marriage as constitutionally protected, it would be accepting an argument that would cast all those who cling to traditional beliefs about the nature of marriage in the role of bigots or superstitious fools. Well, when the court did recognize the constitutional right to same-sex marriage, it went out of its way, in an opinion by Justice Kennedy, not to say anything like that. It did not say those who oppose same-sex marriage are bigots or superstitious fools. To the contrary, Justice Kennedy's opinion for the majority of the justices of the court said that many who deem same-sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises, and neither they nor their beliefs are disparaged here. He went on to say, to emphasize that those who adhere to these religious doctrines may continue to advocate with the utmost sincere conviction that their view that same-sex marriage should not be condoned. And the First Amendment protects their ability to advocate that. So the court was not saying that that was an illegitimate or disfavored idea in the way it might have if race had been at stake. The dissenters in that case thought the court had not gone far enough. They said it's not enough to give them the right to advocate against gay marriage. Their religious convictions are going to come into conflict in certain cases with gay marriage, with same-sex marriage. Justice Thomas saying that religious liberty is about freedom of action, and they will be inevitably asked by the state to participate in this thing that they find morally objectionable or religiously prohibited. And that's why I think that the justices of the court, although a majority of them certainly approve of same-sex marriage and the constitutional protection of same-sex marriage, do not see this as quite like a question quite the same as interracial marriage. And in particular, they think that those who remain religiously and philosophically opposed to it have legitimate grounds for doing so, even though they have lost in the highest court of the land on the constitutional question. And that's what prompts our case here. If this were a racial discrimination case, I don't think anyone thinks the court would have granted review of it. But it's not, and the justices decided after 13 conferences, they held it over 13 times before deciding a baker's dozen, right? Yeah. Sure. I think that was deliberate. They were waiting for 13. They held it over 13 times before they decided to take the case, indicating that at least 4 of them wanted to hear the case, and most likely the 4 who wanted to hear the case wouldn't have voted to grant review unless they thought there was a possibility that 5 would vote in favor of the baker, something that would be inconceivable if this were a race case. Finally, just to clarify, so that's sort of the context of it, and just to clarify a couple of the factual questions that might come up here. This is in the materials, but just so you're all clear on it. Two sort of factual questions have been a little ambiguous or contested as this case has been reported in the press and the like. Number one, does this involve a requirement by Colorado that the baker, that Jack Phillips and Masterpiece Bakery, that he write anything on the cake or bake a cake or design a cake of any particular type with rainbow colors or congratulations to Charlie and David? Is that in the case? It's not in the case of this particular couple because he refused to serve them before they even discussed what the cake would consist of. But the injunction that the Colorado courts have entered against Masterpiece Bakery seems to suggest that if they would put a message on a cake for an opposite-sex couple, then an analogous message could not be prohibited with respect to a same-sex couple. And then there's the question about whether he was willing to sell them a pre-made cake, not a customized cake on their behalf, but one of the ones in the fridge that he had made for weddings, a generic wedding cake. The record is a little bit uncloudy on that, but his lawyers are insisting that he would have gladly sold them that kind of cake as long as he didn't have to engage in the process of designing it, knowing that it was going to be used for a same-sex celebration. But there's some ambiguity in the record about whether that's so, and it's not exactly clear which way that cuts as a matter of law. So with those things out of the way, I'm going to just tell you very briefly how we're going to work this. Ordinarily, if this were the U.S. Supreme Court, the marshal would gavel the court into session, would say, oyez, 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 all persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Everyone would be standing solemnly. She would gavel the proceedings to a start. Everyone would sit, and the Chief Justice would call the case, and the first advocate for the Bakers, which Professor Vladeck is representing here, would come to the podium and begin the argument. And there would be 30 minutes per side, with a rebuttal for Mr. Vladeck at the end of Mr. Gottesman's argument. He would get the first word and the last word usually consisting of only about 3 to 5 minutes. We're going to do things a little bit differently here. We're not going to have you stand up and gavel in. We're a little bit more informal than that. We want to get right to the merits. We're going to have 15 minutes per side, and without a rebuttal. So each side will get 15 minutes, which is about half what the actual argument would be. But these guys are so good that they will get in more in those 15 minutes than the actual advocates would in 30. And we're going to be a little bit nicer than the Supreme Court justices actually are. We're going to try not to monopolize the time among the 5 of us. And we're going to give each advocate 2 minutes to make their case at the outset, which you might think is no time at all, right? When's the last time you were able to say anything meaningful in 2 minutes? Well, as it turns out, the Supreme Court justices typically allow you only about 10 seconds or 15 before they're interjecting, and there's a reason for that. They just want to know what the answers to their questions are. That's why you are there. But we're going to allow them 2 minutes each to start before we start peppering them with difficult questions. So with that, Mitch, I think we're ready to go, and I now step into the role that I've been waiting my whole life to play. This is First Amendment protected activity, creative activity. The court will hear first number 16111, Masterpiece Cake Shop Limited versus the Colorado Civil Rights Commission. Professor Vladeck.
Mr. Chief Justice, and may it please the court. This court has often declared that if there is any fixed star in our constitutional constellation, it is that the First Amendment prohibits the government from prescribing what is orthodox in politics, religion, or in other matters of opinion. For this reason, this court has invariably overturned efforts to coerce adherence to political or religious views, and as best as I can tell, this court has never compelled an artist to create a work of art against the artist's will. Yet that is precisely what Colorado has done in this case. It has conscripted Jack Phillips, the owner of Masterpiece Bakery, to do exactly what his religious beliefs forbid, to celebrate gay marriage by creating a custom-made wedding cakes. And compounding the First Amendment injury, the ruling below compels Mr. Phillips to create cakes that may bear inscriptions antithetical to his religious beliefs, such as God bless this marriage or Jesus loves us. On the other hand, Colorado rejects claims of religious discrimination when secular bakeries refuse requests by Christians for customized cakes that criticize gay marriage. Colorado thus has prescribed an orthodoxy. It supports gay marriages and punishes those who object to it on religious grounds. Now, the decision below violates Mr. Phillips' First Amendment rights in 2 ways. First, it forces him to create works of art against his will, and it forces Mr. Phillips to express support for gay marriage, both by words and deeds, notwithstanding his religious objections to gay marriage. And to make no mistake,
Counsel, I just want to be clear about what the ramifications are of your argument. You would take the same position, I take it, if the sincere religious objection was to interracial marriage or interfaith marriage, to marriage between persons who were not of the same faith as the baker. Is that correct?
no, that's not, Your Honor. And that question really begs the question of who's being discriminated against here and the nature and strength of the state's interest in sanctioning Mr. Phillips.
So, counsel, are you saying that the state's interest is less here than in those instances?
No, I am saying the balance is different. This isn't a case against racism, religious hatred, or invidious discrimination against gay people. And the idea of equating this case to run-of-the-mill discrimination wrongly vilifies millions of good and decent people whose faith...
Counsel, I don't mean to vilify anyone, but I would suggest that there are people who have sincere, honorable objections to interfaith marriage, for example. Why could a baker not refuse to bake a cake that said, God bless this marriage, or congratulations to two people, if his or her beliefs ran contrary to the religious legitimacy of interfaith marriage?
With all respect, Your Honor, the history here is completely different than the ones of interracial marriage, which has been recognized.
I didn't say interracial, I said interfaith.
Or interfaith. Recall that this case arose in 2002. Until this court's decision 2 years ago in Oktoberfeld, most states did not recognize gay marriage. And
so are you asking only for retrospective relief?
I'm trying to explain why this case involving gay marriage is different from the ones that you're postulating involving...
Well, let's assume that we're in 1967.
Gay marriage would have been unlawful in every state of the country.
That's right. And so let's take my example of interfaith marriage. In other words, let's say there's a new law that did not exist 3 years prior to that. Is there a period of time in which discrimination is okay until it becomes more widely accepted as a norm?
You know, you keep on using the words discrimination as if this is an act of discrimination rather than an act of religious faith.
Well, I mean, he clearly was discriminating by saying that he will not provide the usual commercial service he sells to everyone else to same-sex couples. That is discriminating, and it's classifying two groups of people, the customers he will serve and the customers he won't serve with the same product, right?
That is correct, Your Honor, but the question is, why is he engaged?
But can you give me a single case in the history of this court in which we have allowed a commercial business to refuse its services based on a constitutional claim of exemption? Any constitutional claim of exemption?
No, Your Honor, I don't think
And why
there
would
is
we
such
want
a
to
case.
start with this one? Somebody who makes wedding cakes, who's especially given the absence of any real possibility that anyone's going to think he really supports gay marriage just because he sells a wedding cake. Doesn't it make a difference whether or not there's really a fear that he's going to be viewed by his fellow churchgoers as having become a big supporter of gay marriage or something just because he complies with the law?
Well, there are two responses to your attribution point. Let me address that first, because you asked many questions. The attribution, I mean, one of the concerns I have is that if the attribution, the lack of attribution is as you say, then the ALJ's ruling makes no sense at all. Because the ALJ made clear that there were situations in which individual bakers could refuse to bake cakes based on one example the ALJ used was a black baker could legitimately refuse to bake a cake for the Aryan nation. Not necessarily because it didn't fall within the statute, but because it would be offensive to him.
Well, but I have a more fundamental question, which is, why is it that him baking a cake conveys any message at all? I would say if I'm a Jewish baker and I bake a cake for a party to celebrate a child's first Holy Communion, Or if I'm a Catholic baker and I bake a bar mitzvah cake, that doesn't convey any message about the baker's religious beliefs. It conveys a message from the people who bought the cake, presumably the kid's parents.
So let me answer that in two ways. One is there are exceptions to the Colorado rule based on notions of unmistakable offensive messages. And so there are lots of exceptions based on the perspective of the individual baker. But more importantly, it didn't matter in Barnett, for example, that an observer would know that the children were forced to salute the flag because they would be disciplined otherwise. It didn't matter in Woolley versus Maynard that the people of New Hampshire would understand that Mr. Woolley objected to his license plate but didn't make it.
But Mr. Vladeck,
it's the coercion that violates the First Amendment, so not the attribution.
That's true, but in those cases, of course, the school children in Barnett and the drivers in Woolley did not hold themselves out as commercial vendors to the public at large, something your client has decided to do. But I want to see I just want to see how far your theory runs here. How much does it depend on the fact that this is a wedding cake and maybe even a customized wedding cake? What if instead he held out his services as a caterer for large events and he did weddings all the time? And instead of making a wedding cake, he were poaching the salmon and making the ice cream that was served at the meal. Would you still have a First Amendment? And he thought he was doing so in a very creative way. He was beautifully plated and everything else, okay? Would you still have a case there, or does it depend on a wedding cake?
I think there are two things that distinguish this from your case. One is, this is not a run-of-the-mill service. The reason why the respondents went to Mr. Phillips was they wanted a special cake to celebrate a special moment in their lives, right? So they wanted somebody who could basically convey the message they wanted to convey to their friends. So this was a work for hire. This was a conventional work for hire, just the way when Pope Julius II wanted the Sistine Chapel painted, he went and got Michelangelo, who was an artist for hire. Yes, a cake is somewhat different than the Sistine Chapel. I'll acknowledge that. But this is a
matter of degree, though, right?
Could I ask you,
does your
on the
argument
limit of your theory, I just wanted to know, suppose he's got 5 cakes that are specialty cakes that you can pick from, 1, 2, 3, 4, or 5, and a couple comes in and says, we want number 3. Does he have the same First Amendment claim, and if not, why not?
I think this First Amendment claim might be different. I think it, for example, and this goes back to one of the prior questions, if he refused to sell any cake at all, then I think this is...
These are all wedding cakes.
Right.
I'm talking about wedding cakes. Well, there are 5 special wedding cakes, and you can pick 1, 2, 3, 4, or 5, and he refuses, in my hypothetical, to sell a number 3 because it would violate his conscience, because it would be celebrating a gay wedding against his beliefs.
I think that would be a harder case. I still think he would prevail. And one of the questions I would have about your hypothetical is he going to be forced to inscribe on that cake something he might with a heterosexual couple, such as Jesus loves you or God bless this marriage? If he's forced to do that, that is a fundamental First Amendment violation, regardless of whether the cake
What about if Justice Gornstein's number 3 has no writing, no special colors, no figurines, no 2 grooms, nothing on it?
I think that's a harder case, but I still think he prevails because what is going on here is the state is forcing him to surrender his First Amendment.
But it's different from the salmon somehow. The cake is different from the salmon, even though...
I missed the salmon. I thought you were talking about general catering, Your Honor.
Okay, general catering. It can be pot roast if you'd like, whatever, or a vegetarian option, a vegan option. That's fine.
Right. I think the pot roast, the salmon, the pre-made or sort of standard cake, That's a harder cake. I still think he wins. And let me.
How about the
People-
person who does the tuxedos for the weddings, and the couple comes in and said, "We want this. You know, this is the greatest tuxedo place in the state, and we want to get our tuxedos from you." And he says, "No, you can't rent the tuxedo from me."
I think that's a more difficult case.
What about florist, counsel?
Because there's no, because in this case, not only is he being forced to essentially assist in a gay wedding, but he's being forced to create something that otherwise doesn't exist.
Well, let me ask
Counsel, can I just ask about florist? What about florist? A florist creates a beautiful arrangement. This florist thinks that he's the Michelangelo of flowers.
Again, all of these questions raise exactly the concern the Chief Justice, Your Honor, raised in Oktoberfeld, which he said today's decision creates serious questions about religious liberty. Many good and decent people oppose same-sex marriage as a tenet of faith.
That may well be,
but what about our
you
future?
need to have a limiting principle, it seems to me. If your rule is any business that has any kind of expression that is involved in what it sells can turn away gay people based on disapproval or people that are getting married. What about a lawyer whose main practice is prenuptial agreements and refuses to do any of those for a gay couple? He expresses himself in the way he drafts each agreement. Is that governed by the rule that you would have us adopt?
Well, under Colorado law, which is undoubtedly drafted by a lawyer, lawyers are not covered by the public accommodation law.
It was a hypothetical question.
Yes, I think under the Colorado ruling, the answer is lawyers would have to serve that couple, and I think that would be a violation of the First Amendment.
So, counsel, you're arguing that for same-sex couples, whether it's a prenuptial agreement or flowers or cakes or whatever, if there's a sincere religious belief, a commercial enterprise can decline to serve that category. Is that correct?
Well, this injunction runs against Mr. Phillips.
Well, but we are not.
Remember,
We have in mind something broader than your particular client, as you well know, and we're going to be communicating what the rule will be in future cases. What should that rule be?
Well, I think after Burwell versus Hobby Lobby, a closely held corporation, and I don't know whether Masterpiece Bakery is entitled to First Amendment free expression claims, and that is the essence of this case, which is, does Mr. Phillips surrender his First Amendment right to abide by his basic tenets, which until 2017 were recognized broadly in the United States? Remember, this case arose in 2002 when the Constitution of the state of Colorado forbade gay marriage.
Thank you, Mr. Vladeck. Professor Gottesman will hear from you next. Please order in the court. There is no applause in the Supreme Court of the United States.
Mr. Chief Justice, and may it please the court, the Colorado statute that Mr. Phillips wants declared unconstitutional is aimed at conduct, not speech. The conduct forbidden is treating customers differently based on their race, their sex, their religion, or their sexual orientation. If a store sells a product to white people, it can't refuse to sell that same product to people of color. In like fashion, if it sells a product to heterosexual couples for their wedding, it can't refuse to sell that same product to same-sex couples for their wedding. In this case, Mr. Phillips refused to sell a wedding cake to Charlie and David, even though he'd happily sell that same cake to a heterosexual couple. That's a clear violation of the statute. But Mr. Phillips says, but my cake is protected by the First Amendment. So I can discriminate and the state can't do anything about it. Now, it's true that a custom-made cake might qualify for First Amendment protection. This court has held that sculpture is a form of expression, protected by the First Amendment, even when it conveys no message. And so presumably a cake is a kind of special cake. A custom-made cake would be a kind of sculpture and would enjoy some First Amendment protection. What does that mean? It means that the state can't forbid Mr. Phillips from making custom-made cakes unless it has a compelling governmental interest in doing so. But it doesn't follow that the state can't forbid him from discriminating in the sale of such cakes. There's a well-established doctrine that applies when a law that's aimed at conduct incidentally bumps up against a First Amendment protected activity. That doctrine was first announced in O'Brien and more recently applied in the Fair case, the case of law schools who didn't want the military when it discriminated against.
Counsel, I wonder if you could shift over to the following hypothetical. Suppose I'm an artist who paints original works of art on commission, and a gay couple comes in and says, we want you to paint a painting that commemorates our wedding, and the artist says no, because I don't believe in gay marriage. Your position is the government can require the artist to create a painting that celebrates gay marriage.
It can require the artist to create a painting that is the same as a painting he would sell to a heterosexual couple.
Well, it's never exactly the same. They're unique works of art, and you're saying that if a heterosexual couple comes in and says, I want you to paint an original work that celebrates, the only requirement is that it celebrates our wedding, you would say he has to do an original work of art to celebrate a same-sex couple's wedding.
Well, first of all, an artist is kind of different from a bake shop because artists don't honor every request to make a painting.
Well, that's why I'm trying to figure out whether you think the principle applies to artists or not.
If we have an artist who says, I will paint a painting for any heterosexual couple who asks me, and to have in that painting a man and a woman, and now I have a gay couple coming in for same-sex marriage and asking me to paint the identical painting except it should have 2 men or 2 women, I would say that would be discrimination to make that distinction. Now, there is a big difference, I want to say, between that case and this one. Because in this case, nobody's going to know who baked the cake, right? In an artist's case, you likely will. The artist will likely sign it. Wedding cakes, at least at none of the weddings that I've gone to, gay or straight, was the name of the bakery signed on the cake. And so in this case, we don't have somebody who's...
Yeah, but you know, at the same time, you know, I've been to a lot of weddings where people say, where did you get that wedding cake from? And pretty soon that information passes very quickly through everybody who's at the wedding. Are you saying if they all now know that the cake was made at this particular cake shop, the case comes out like the artist?
So what does the cake look like? Does it have writing on it? Is it just a shape? What is it?
It's a sculpture, as you say, that's protected by the First Amendment and now is signed effectively by the artist because everybody knows who made it.
There's a big difference between signing it and making a case to a customer's specifications. This is not a statement by the bakery. It's honoring the request of a customer. I would like a cake that looks like X.
No, but what about, but why is that? I mean, in Barnett, no one thought that Jehovah's Witness students actually pledged allegiance to the flag. Everyone understood that they were being required to do so. In Barnett, in Woolley, no one would have assumed that every driver in New Hampshire would have gladly died before living free. And so the issues there were not were not mistaken attribution. The problem was that there's something constitutionally offensive about requiring an individual to attest, to say something that he or she does not believe and finds morally objectionable. Isn't there a fundamental constitutional problem with that?
Well, the court thought not in the Fair case, which is more recent than both Barnett and Woolley, and said about those cases that it would trivialize the protections that were granted in those cases to apply them to something that doesn't involve such a demand on the person to mouth words.
That's right, but in that case, The compelled speech was that the law schools had to put out an email to the students saying the Department of Defense interviewer will be in room 231 at 2:45 today.
No, it did much more than that, Your Honor. It compelled the law school to transmit to the students, because it did this for other employers, to transmit whatever information the employer wanted to be communicated to the students. And in the case of the military, that information was openly gay and lesbian applicants need not apply.
Counsel, another way to distinguish those cases is to draw the line between commercial and non-commercial. Now, what do you say, however, to your opposing counsel's point that after Burwell versus Hobby Lobby, the commercial, non-commercial distinction has evaporated, or at least been weakened?
So Hobby Lobby was not a constitutional case.
Right.
It was the application of a statute. That statute applies only to the federal government's actions. It doesn't apply to the actions of the state. And the claim in Hobby Lobby was not a free speech claim. It was a freedom of religion claim. So all the court held in that case is there happens to be a statute that says that commercial people can't do this, and we will apply that statute in a certain way because of the RFRA, the Religious Freedom Restoration Act. There was no holding in Hobby Lobby that the Constitution would forbid the government from banning that.
Well,
Okay, counsel, but let me just take you one step farther, and back to your O'Brien test. All right, you're correct about RFRA, the statute. Back to your O'Brien test, though. Is there not a less intrusive alternative that states could follow in this situation in terms of granting exemptions to what are going to be a tiny number of people who don't want the business associated with, or a tiny number of businesses, commercial establishments, who don't want the market associated with a particular group?
So here's what the court in Fair said about the O'Brien doctrine. This is the doctrine that says that when you have a statute that's aimed at conduct, what are we going to do about the fact that sometimes it will incidentally affect speech that might be protected? The court said in Fair, an incidental burden on speech is permissible under O'Brien so long as the neutral regulation promotes a substantial governmental interest that would be achieved less effectively absent the regulation. Now, surely there is a substantial governmental interest in preventing discrimination against people who are gay or lesbian or transgender. And in terms of, is there another way that would more effectively protect against that discrimination? What could be more effective than saying, don't discriminate? In this case, both of the elements of that doctrine clearly apply and say that even though this may, in some cases, not in the case involved here because they didn't ask for a custom-made cake, but in some cases where arguably the cake would have some First Amendment protection, nevertheless, if the state has a substantial governmental interest that can't be as effectively accomplished in another way.
Could I ask you about a hypothetical where I'm a tattoo artist and I make all kinds of tattoo designs for people, including ones that say Black Pride or various symbols of Black Pride. And a white person comes in and says, I want a white pride tattoo. And I say, look, that's associated with Nazism as far as I'm concerned. And the state comes back and says, you're discriminating on the basis of race when you don't allow white pride tattoos, don't create white pride tattoos. Does that, does your law surmount, the non-discrimination law surmount the First Amendment claim in that case?
Well, first of all, this statute, that would not violate.
No, but I'm in my world, in my hypothetical world, it does violate the statute, and the state says so. It's discrimination based on race. Once the state has said that, does that mean there is a First Amendment right to resist that statute or not?
So I would say if we find that the reason for this discrimination is race, and the race of the purchaser, because remember, that's what's involved here. This protection is protection for the customer. You cannot discriminate against the customer because of his race or sexual orientation.
Well, and that's what's found here. You can't, they're saying this is discrimination against the white customer because he can't get a white pride tattoo.
Yeah.
Now, you could disagree with that, but the state has decided that question,
Gotcha.
that that's discrimination on the basis of race against the white customer. Now, is there a First Amendment? Does that mean that the First Amendment doesn't protect that person from having to write a tattoo that associates him with Nazism?
Yeah, so the answer is yes, that would be perfectly okay for the state to forbid that. And let me take an example that's closer to this case, and that it poses the same issue. Suppose that Charlie and David had said, we want you to put writing on the cake. Congratulations, Charlie and David, on your marriage. That's not the bakery speaking. Nobody thinks the bakery is congratulating them on their marriage. The bakery is writing down what they asked the bakery to write down. All the bakery is doing, think about a printer who's printing up a pamphlet, and the pamphlet gets published. Are we going to say, oh, the printer has spoken? Of course not. The printer is just communicating.
Just so I'm clear, I have to, if I'm in the business of doing tattoo artists and I have a state that wants to regard that as discrimination on the basis of race, I've got to write tattoos that are basically Nazi tattoos on people.
And what is the speech that you are engaged in when you do that? You're taking a needle and putting something on somebody's skin that that person wants to say.
But you're spending hours doing a beautiful design of white pride or a swastika. I think most of us would be deeply offended by those. We would feel deeply uncomfortable about that.
I would as well. But there are people who have swastika tattoos, right? People are doing it.
Justice Bernstein's been trying to get in.
So I'm just wondering whether Colorado law would prohibit me from operating a business that provides goods and services specific to a certain culture, religion, or ethnicity. So suppose I open the Confederate Bake Shop that celebrates Southern white culture and heritage, and all my baked goods have little Confederate white pride theme. Does Colorado law compel me to sell treats that celebrate other cultures as well?
No, this statute would not, but one could theorize a statute that says you're forbidden to sell only Confederate objects. Then we would have the issue of whether that is a violation. But see, here's what's different. That statute is aimed at speech. This statute is aimed at conduct. It is aimed at stopping discrimination against people. And we got a baker who says, oh, my creations are protected by the First Amendment, so I'm free to discriminate against people. That's what makes these cases different. This is not a statute aimed at the content of what you say. It is aimed at requiring that you treat one group of people the same as you treat another, at least in the categories that the statute deals with: race and sex and religion and sexual orientation. And with respect to these and incidentally, if this baker refused to make a cake for an interracial marriage, despite what, with due respect, the Chief Justice said, and certainly what Mr. Vladeck said as well, there's no question that it would pose exactly the same issue as this case. This statute forbids discrimination against race, and it forbids discrimination against sexual orientation. For refusing to make a cake for one is no different than refusing to make for the other. You're discriminating on a forbidden ground. And I don't think the court can figure out a way to say that one is a violation of the First Amendment and the other is not.
Thank you. The case is submitted.
Now you can clap.
Thank you all for a really, really superb argument, especially our advocates. Thank you very, very much. What? And our judges, thank you. So these are all things you will not see at the real Supreme Court. We will not applaud for the advocates after they finish, or for the justices at the bench. And we're going to do some more stuff that we don't do at the Supreme Court. We've now got a great opportunity to hear, immediately after an argument, from the advocates and then from the judges, their thoughts on what we just did. Let me leave it open-ended and turn it over to Professor Vladeck and Professor Gottesman. Share some initial reflections, if you would.
Go ahead.
You go first.
All right. First of all, I rarely get intimidated arguing in court, but this bench is amazing. I mean, you've heard about their expertise, but Nan and Paul have enormous expertise in this field of the law. And, you know, Dory, Marty, Irv are just incredibly knowledgeable about the Supreme Court. So this is a hot bench. The problem that the plaintiffs
Hot
have...
the way you guys think.
the problem the plaintiff has here, the bakery has, the petitioner has here, is, and I struggled with this, is what's the limiting principle? And this is what Mike just hammered us on, which is, I think the court will be somewhat sympathetic to the baker. I mean, Marty's introduction talked about the court's opinion in Obergefell, where the court is sympathetic to people who have deep-seated religious views that gay marriage is simply not appropriate. So the court is not going to see this case the way it might see the kinds of cases Nan was honing in on. Racial bigotry, real invidious religious discrimination. On the other hand, there is, at least I haven't found it, a stopping point where the court can say the baker wins without opening the Pandora's box that Michael's talking about. So I actually think the court may rule for the baker, but the court is going to struggle to figure out how you rule for the baker, but you don't sort of open up the kind of sort of rampant discrimination that Michael is talking about.
So I'm inclined to think, you know, I have no doubt how this case ought to be decided, but what I think ought to be the Supreme Court's decisions coincide with the Supreme Court does about 15% of the time. Right? It used to be different. I'm old enough to remember when it was different. So I think the court is going to be looking for a way to rule in favor of the baker in this case, and there is a very narrow way. I mean, I think there is a way they can make this a very narrow case. The injunction that was issued by the Colorado court forbids any distinction whatsoever that the baker might make. Anything you do for one, you got to do for the other. That would include writing passages on it. It would even include the most annoying hypothetical. There's nothing more annoying than when the justices ask you a hypothetical you don't have a good answer for. And the one about the painting is the one that I struggled with. That the court could say, look, you know, we don't have to decide that every violation of this statute is a violation of the First Amendment. But because the injunction is so broad, if we can think up some limited category that it would be, the baker would have a First Amendment right to resist, that's enough to say that the ruling below is improper. And so they might go with, you can't make the baker write words on the cake that the baker doesn't want to write, although I mean, I really do have a problem with that one because nobody thinks that the words on the cake are the baker's words. They're the customer's words. They might think of some other narrow way they could do this. Plainly, you know, in this case, the actual case, if the Colorado court had limited its ruling, Charlie and Dave came in and said, we would like a wedding cake. They didn't say what kind. They didn't say custom made. And Mr. Phillips said to them, I don't do baked goods for weddings. Sorry. End of conversation. So it could have been an off-the-shelf case, a cake that had no First Amendment protection at all. Because even the bakery is arguing that it only gets First Amendment protection for its creative cakes, not for its routine cakes. But because the injunction was so broad, it gives the court a big landscape in which it can chip away and say, here's some context in which we would say the bakery could refuse to do this. Therefore, this injunction is too broad, and we send the case back at least to narrow the injunction.
Thank you both. As we turn to the bench for commentary, let me throw out a question, which is, if we're in the business of predicting how the court's going to rule, we hear a lot about 4-4 splits and Justice Kennedy in the middle being the deciding vote. Is this one of those cases?
So, before I answer that question, I want to give the students some sense of procedurally what would occur at the end of the argument. So the argument would take place on a Monday, Tuesday, or Wednesday morning, and that Friday morning, the justices would meet at 10 a.m. for conference, just the 9 of them, no one else in the room. As a matter of fact, the junior justice, which is now Justice Gorsuch, has to get up and answer the door and bring baked goods to the other justices or whatever they'd like. It's just the 9 of them. No one else knows what goes on, although they could share what goes on with their clerks if they choose to do so. And they will take a tentative vote. And in the Roberts Court, that starts with the Chief Justice giving his view of the case, saying something about it and saying what his tentative vote is. And then in decreasing order of seniority, they each vote. And at the end of the vote, the tentative vote, the senior-most justice in the majority, the side that has secured the most tentative votes, and that would be the Chief Justice if he's in the majority, will assign one of the justices in that majority the responsibility to draft an opinion to hold that majority, an opinion that at least 5 or more of the justices would agree to sign on to. And that justice takes this assignment back to chambers and talks to one of his or her clerks, and they start writing an opinion with an eye, most of them with an eye toward trying to hold a majority. And then they distribute their draft to all the other justices, and they see how many join in. And at that point, those who still want to dissent from the majority rule or try to change the majority start drafting their own opinion, going the other way and showing what the flaws are, the apparent flaws in the draft majority opinion. On rare occasions, the dissenters might convince one of the members of the majority to switch between the time of the conference and the time of the decision is issued, but that probably only happens fewer than 5 times a year. That is to say, in about 5% of cases at most. So it's a hard thing to do. Usually the vote at the Friday conference typically becomes the vote, at least the outcome of the decision when the court issues it, which will here probably be sometime in the spring. As for predictions, I do think that the court will find, I was struck by Professor Gottesman's final statement as the clock was running, which is, I don't think this court is capable of issuing a decision that will be limited. I don't think he would say that to the real Supreme Court justices for fear that the chief would say something like, just watch us. Or so. They have the capability of trying to craft very, very fine distinctions. And I would predict that at least with respect to cakes that have some expressive component, like writing or figurines or maybe a rainbow layer, the court will rule for the bakery. As to those that are not in that way expressive, but that are only custom made, I think it will be 5-4. That's going way out on a limb. But I think it will be a very close vote as to the what I'm calling the expressive cases. Nan, what's your prediction?
I will firmly predict 5-4. But I think it's going to be very close. I also think that it could come out either way. I think that it is true that the justices on this court are going to, 4 of them, and also Justice Kennedy, will be sympathetic to the baker. But I think that I think that they are in a fix in terms of coming up with any principled way to embed that in the law. I think that I mean, I noticed that counsel for petitioner, David, refused to accept any of the analogous situations. And to me, that was quite problematic, although that's a critically important strategic decision that David made and that counsel for petitioner will have to make as to whether to say this particular exemption, religious exemption, is very narrow because of the sort of sincerity of the belief and so forth, or whether it's more attached to the category as to, as that it is aimed at. In other words, it wouldn't be acceptable, assuming a legitimate and sincere religious belief, it wouldn't be acceptable if aimed at different sex couples of different races, or divorced, or interfaith. That's very, very different, and the Obergefell decision is so new. I think that is deeply problematic. I think the petitioner would be better served by saying that there is a space for a religious exemption to any and all categories. You can't have a different religious exemption applicability to one category and not another category. And I think that Justice Kennedy would be very hesitant to go down the path of singling out same-sex marriages as being the category for which a religious exemption sounds logical or acceptable or is morally sympathetic, whereas for interracial or interfaith or others, well, that's different. That's not morally, it doesn't sort of sound morally as acceptable, because really that's ultimately just a moral judgment. So my sense is that could backfire in terms of Justice Kennedy's sympathies. I think Justice Kennedy is, however, quite sympathetic to the sincere religious belief perspective of an individual. Now, here you have what the attempt to breach what used to be kind of the accepted line, which is the line between commercial and non-commercial. And I thought that if I would give one recommendation to counsel for respondents, I would have referred to the baker not by name or as a person or as an individual, but the business. The business this, the business that, the bakery, to reinforce that old traditional point of the commercial, non-commercial line. Now, it may be that the commercial, non-commercial line is being eroded. I think that, although Burwell is not on point for the reasons that Professor Gottesman said, it signals a certain willingness to tolerate, I think, an invasion of that non-commercial, commercial line. So I think it's, I think the court in this situation, it's got a few possible ways it can go. In a case like this, which is so fraught, I'm not going to go through what the sort of doctrinal ways it could go, but really I think the question is, will the court, or 5 justices of the court or more, attach or look for the procedural opt-out, whether it's the narrowness or the breadth of the injunction or the flaws in the ALJ reasoning below or in the Court of Appeals reasoning, the Colorado Court of Appeals below. Running counter to that is the fact that I'm sure the justices are aware there are a whole slew of other cases out there. There are florist cases, there are printer cases, there are photographer cases. These cases are not going to go away. So I think one of the points of tension will be between the idea of finding the minimal basis for deciding a case on technical grounds if possible, kick the can down the road, let the law develop some more, and deal with the case, another case as it comes to the court.
We have to go to
I'm sorry.
questions soon, so
All
I
right.
apologize.
So, no, that's okay. But that I think is going to be one of the main issues for the court.
Dory?
So I'm just going to make it really brief because I haven't really thought about this that deeply. I've thought about it enough to feel like I really want respondent to win this case. And part of that is because I spent my whole career arguing discrimination claims, and I just feel like this would be very dangerous to start eroding away discrimination protections. I think particularly, I just wish that Mike Gottesman were arguing this case because I think if someone could convince them, it would probably be Professor Gottesman.
Paul?
Just quickly, I agree it's going to be a 5-4 case and that Justice Kennedy will likely decide it. I think it's a hard case for him because if there are two things that Justice Kennedy cares about, it's freedom of speech and gay rights. And so he's got to figure out how do I deal with those two things in a case like this. And it's a tough case for him in particular. This is a really good example of what smart lawyers do when they want to try to change the law. They find a very sympathetic set of facts, a sympathetic person to represent. And those of us who did work on gay rights stuff over the years did the same thing on the other side. That creates a very troubling prospect that the court will be influenced by that to do something which I think would have very serious consequences, which is breaching the wall, as Nan said, of allowing commercial businesses to claim constitutional exemptions from anti-discrimination mandates, either just as to gay people, LGBT people, or as to other groups and other kinds of claims. I think that it's going to be difficult to cabin what happens from that, and we saw that with the answer about the prenuptial agreements and lawyers being able to return away clients who they would otherwise serve, and I think that's just the beginning of where this could end up if the court thinks it can limit it, because I don't really see how they can.
Irv?
So just for prediction's sake, last term, 79% of the cases in which the court granted certiorari, it reversed. So that would tell you there's approximately 4 out of 5 chance that they're going to reverse in this case. It's true over the, sometimes it's not that high. Over the last 5 years, it's about 72%. And so there's a significant chance anytime, the odds are anytime the court grants, it's likely to reverse. Sometimes the cert process doesn't tell you quite as much as it does this time. Here, they're really, one of the ways the court grants, reasons the court grants certs in which it's not as likely to reverse is when there's a real conflict in the circuits. And then it takes the case to sort out the conflict and not necessarily because it thought the decision below was wrong. And here, while a conflict was asserted, there really wasn't one. And so I think the cert grant in this case represents a pretty solid prediction that 4 people at least, which is what it takes to grant certiorari, are ready to reverse. Now, sometimes when the court grants, Justice's initial impressions change from when the what happened at the cert stage, and so it can change. This time, not as likely for the reason that Professor Liederman talked about. The court had 15 weeks, different conferences on this case, and I am quite sure that a lot of not quite sure, but pretty sure that there was writing back and forth already on this case, on the merits of it. And so my guess is the justices are fairly firm in their views on what's going to happen here. And so that's what I have to say about predictions.
Thank you all. I'd like to add some additional voices to this conversation, and that's yours. We'll take some comments and questions from our audience. If you are upstairs in any of the simulcast rooms, please feel free to make your way down, and we'll call on you as well. Do I have a first question? Do I have a first question? Yes, in the back, sir, in the back by the column. If you stand up and say your name, and then you can ask your question.
Hi, my name is Michael Lee, I was intrigued by one of the hypotheticals that one of the justices talked about, which was the printer, and whether or not people confuse the printer speaking or saying something, believing something. And the reason why that hypothetical stood out to me was that the printer seemed a lot more impersonal than, say, tattooing on someone. And I wondered if this dimension of, say, we talked about artists. I wonder if there was a dimension that could be at play in this case in terms of a difference between asking the artist to create something where they have to, create something with their hands, as opposed to a company that, you submit a piece of artwork to that you want put onto a t-shirt, and all they don't really have to create anything with their hands, but they sort of just have that artwork go through their process and create the t-shirt. If that kind of, I guess, impersonal process has any kind of bearing in what defines freedom of expression or speech. Thank you.
Anybody?
So courts have defined art very broadly. Artistic expression has been found, Mike's example of tattoo artists, paintings, fiction, music without words, sculpture, stained glass, engraving, nude dancing, everyone's favorite, movies. But printing, I haven't seen a case, at least printing of the kind you're talking about, which is just replication of something else. So we'll find out down the road.
I think on the speech claim as opposed to the religion claim, which we haven't talked about for lack of time, I think you're right that they're going to try to draw a distinction like that. I'm not sure it's going to be between using your hands as much as using your creative functions, right? If it seems rote, like a printer, they won't want to go there. But to the extent you have to bring to bear your Michelangelo skills, that will be the constitutional test.
Right, but an advocate will try to think of analogies. This is all about a battle of analogies, and if you're trying to minimize the creative aspects of it, you talk about the analogy to a printer as opposed to a Sistine Chapel or whatever.
Let me take another question. Do I see somebody out here? Yes, sir, in the back. In the suit coat. If you'd say your name and ask your question.
Hi, my name is Alejandro Garcia Morales. My question was sort of following on the previous question. To what extent does this hinge on sort of the baker's refusal to actually sell? Say the baker was sort of giving away cakes on a day. Say like Ben and Jerry's does a free and cone day, right? And let's say Ben and Jerry's is a conservative institution, and they don't believe in gay marriage, and then a gay couple comes up and asks for a couple of cones and say, no, you can't have that. But there's no sort of transactional aspect to the exchange of goods. So say that the cake shop's like giving away cakes on a day and does something that does that make a difference in how the case would be treated, or would it just go down the same route of it being considered discriminatory anyway?
So I think it might be different if all Ben and Jerry's is doing is taking scoops of ice cream that's already been made and putting it into cones, saying, but we won't sell it to gay people. I think the argument there is stronger that we don't have speech involved. This is not a First Amendment case. We've only argued this on the speech issue. There is also this religious issue, which is probably a loser for the bakery under existing law, because the Supreme Court has said that when you have a law of general application, you don't get exempted from it because you have religious objections to obeying it. That's why the principal emphasis here has been on speech. And in that case, if the bakery is conceding that just a run-of-the-mill cake is not protected by the First Amendment, it's only our creative cakes that are, then it might be that the Ben and Jerry ice cream doesn't involve the kind of creation that would give it First Amendment protection.
I'm curious, Michael and David, I mean, David came pretty close to conceding that without quite conceding it.
Yeah, I mean,
but the lawyer for the bakery seems to be conceding, thinking the court will draw the line between the pre-made, even though they're very creative, but they're pre-made rather than customized. I don't know which way that cuts, but they seem to be of the view that they think the court won't protect the pre-made cake.
Right, I think they're gonna talk about creativity and, you know, sort of the artistic aspects of this. You know, Paul's point about wanting to, or maybe use, to draw an analogy between a painter is the best argument that they have. The more this looks like the Sistine Chapel, the more likely they are to win.
Yeah, and the implication.
It wouldn't be a pre-paint.
Right.
In other words, a painting you've already created, you couldn't.
Right, unless you have to inscribe it.
Right.
I mean, the inscription matters here.
Yeah, but also there's you know, when you talk about the slippery slope of the court opening something that it can't then close. Right. If you say that every product that you make, so General Motors comes out with a new car this year and its design is slightly different from what it was last year. And they say, see, this is creative. This is protected by the First Amendment. Now we can discriminate against who we want to sell the car to. We don't have to sell it to blacks or to people of sexual orientation because we have an expressive car. I think the court is going to be very reluctant to say that every commercial activity is protected by the First Amendment. It's going to effectively kill the government's ability to regulate business. They're going to, because once you say it's protected by the First Amendment, typically, what you're saying is that the government has to have a compelling governmental interest in order to regulate, and that's pretty high bar. Traditionally, the court has said that when you're regulating business, all you have to do is have a statute that is reasonable. It doesn't have to be the best, it doesn't have to be absolutely necessary, but it's reasonable regulation. That's good enough. This case has the potential, that's one of the reasons the court's going to be very careful about what steps it takes in defining what is the kind of expression that's protected by the First Amendment. It's not going to want to go too far.
We have time for another question. Yes, in the glasses. Yes. If you tell us your name.
Hi, my name is Abby Dembowitz. Given that there were no specifications as to what exactly was going to be on the cake, whether there was going to be writing or no writing, in the event that there wasn't any writing and there would be no messaging as to endorse gay marriage in any way, even if it was a custom-made cake, let's say based on the shape of the cake and involves some type of creativity on the baker's part, does that change this notion of freedom of speech versus what's discrimination, and would that change the potential outcome of this case as to what they were asking for to be on the cake?
So that's a great question. I want to take a shot at that. The court has said that sculpture, et cetera, is protected by the First Amendment even though it has no message. Now, the line they could draw is to say, well, there are things that are protected by the First Amendment in the sense that the government can't forbid you to do it, but that because there is no message, you have no reason to be discriminating against people by selling them that standard cake with no special writing or anything. You are not conveying a message that you support. Yes, I think that's a very good argument, and that's, I think, why the bake shop is kind of conceding that its standard cake would not be a First Amendment violation because they don't think the court's going to be prepared to go for it.
Yeah, I don't disagree. The problem in this case for the state is the breadth of the injunction, which requires the bake shop and Mr. Phillips to basically do for gay couples anything at all that they might do for a heterosexual couple.
So I just want to, I'm not sure I quite heard the question right, but what if it's a creative cake that doesn't have any message on it? I think what the petitioner is definitely going to say that would be that is First Amendment protected.
Oh, yeah.
And that the creative process gives it First Amendment protection, and the message is inherent in the cake. So that any wedding cake celebrates the wedding. And that will be their argument.
In a way, the pot roast doesn't. That's that was their distinction. Right.
Yeah.
Well, I know there are many, many more questions now in the audience. Let me make one quick announcement, okay? Because we are now approaching the end of our time. One of our student groups, which is Outlaw, has scheduled a program for tomorrow for those who would like to reflect more on the case, had strong reactions to the case, and several of our faculty panelists will be there tomorrow at Outlaws program to share additional views if you have additional questions. The program is in McDonough 342 from 1 to 2:30 p.m. There will be some refreshments. So I encourage anybody who's interested to come to that program. For now, that concludes this program, and I hope you will join me in thanking again our judges and our advocates. And I'd also like to thank you and those of you who asked questions and were ready to ask questions. It's great to have your voice as part of the program as well. Thanks very much.
Great. And now we just go out in a
Not really, but
anticlimactic way. Aye.
I wasn't quite as dignified as Professor Side.
Yeah.